What's up, everybody? Welcome back to another video on the ASAP Rocky trial with the lawyer you know. And this video, we are going to focus on some of the infighting between the lawyers in this trial. Tensions are rising. Things are going back and forth between these lawyers saying they're not disclosing this, they're not disclosing that. There's an argument in front of the judge to start day 2 of the trial. We're going to break down what these lawyers are arguing about, if there's anything nefarious going on, if they're breaking any rules. And we're going to focus on that because we can learn a lot when the lawyers start really letting it all loose. And we get to see how a very seasoned judge deals with it, how he shuts it down, and how he makes rulings to protect the fairness of the justice process. So let me know in the comments if you're still following this trial. Make sure you guys hit that like button. Let's get to it. So we've been talking a lot about lawyers lately in high-profile cases, right? Rob and I did the podcast on the Take Care of Maya lawyers. We've talked a ton about the lawyers in the Baldoni and Blake Lively case. We read through what the ethical concerns are and what the code of ethics and the rules of professional responsibility in California, where this ASAP Rocky trial is. So we know what those rules are. It's the very last video I did. We read them in detail. And basically they say you can't comment about stuff that's going on in the trial unless it's public record and unless you need to, because you need to correct some injustice and prejudice that's going on because of negative publicity that somebody else is starting, right? But there are also situations where a court can make an order known as a gag order that can go above and beyond that. And we're going to listen in this case as discussion is going on at the beginning of trial today, where they're doing a bunch of witnesses. It's in the lunch break right now. If you guys are interested in me breaking down multiple or witness by witness or day by day, please let me know in the comments. And if there's enough interest in this case, we'll start doing that. The only witness that I watched today before lunch was the officer that was on scene. The defense finished their cross-examination of that officer. And basically they were trying to say they got him to agree and confirm that there were in fact 7 officers on scene and that they did a thorough search and investigation and found nothing basically. And then we know the victim came and found the casings. So that was basically the end of that witness, who turns out, I didn't even know this, but only in LA. He is the son of Erica Girardi, who is a Real Housewives of something, Beverly Hills, Hollywood, whatever, Orange County. Also, I think maybe stepson of Tom Girardi, or maybe the son of Tom Girardi. I don't know, but he's in that family. So just add intrigue to this case. But all that happened after a busy morning discussing potential discovery violations going back and forth. Each side interviewing witnesses, not taking notes. The prosecution specifically is basically accusing the defense that they're having these interviews, they're not taking notes, it's not appropriate, it's not how it's supposed to be done. The judge is like, that's allowed. I wouldn't do it that way. The prosecutor's like, you basically scolded them, and then they continued to do it. The judge is like, well, technically there's nothing wrong with that. But it all doesn't really matter because the defense says, we're not going to ask them anything you guys don't already know about, right? So we're interviewing them, we're talking to witnesses, whatever it may be. So all of that goes forward. And the judge is like, I am finding there are no discovery violations. Let's move on. And the prosecutor's like, well, actually, there's more. There's more. And so now we're going to kind of get into the infighting, which already before I start this clip, the defense has tried to jump in during the prosecutor talking, and the judge has scolded them saying, do not interrupt each other. Don't do it. Boom.
Or just let them interrupt. The next issue that we would have, Your Honor, is we want to make sure. There have been times where counsel has asked to approach, but he still wanted to be on the record. Our position going forward is that unless it is something having to do with an issue with the jury, the prior time occurred before the jury was selected. Counsel made certain arguments in open court, then he asked to approach, and he made different arguments, but he wanted to do it on the record. Unless the court...
You can see and feel the disdain in ASAP Rocky's lawyer over here as he leans back in his chair. I'm wondering what that bag is on the back of the seat. Is it like product placement? Is that his law firm? The beat? Not bad. But the prosecutor's just kind of arguing about what Taco Pina. I'm going to have to look at, I can't remember what his name is. Taco Pina, I think is what it is. Something like that. And he's saying that he wants to approach, but be on the record. If it's outside the presence of the jury, we get it. But why would you need to do it if the jury's not in here? Why do we need to approach? Why can't we just argue in open court? Almost making it sound like ASAP Rocky's lawyer is trying to hide something from the media or from the public, but still get it on the record.
Orders it, and there's a good reason. The last time this happened, Your Honor, as the court is aware, counsel elected at his request to give a speech that he was very happy with this jury, wanted it to be known that he was happy with the jury.
Give a speech. Stop. Don't interrupt. Okay.
Oh, this is where he yelled at him for saying, stop, don't interrupt.
It to be known that he was happy with the jury.
Give a speech. Stop. Don't interrupt. Okay.
I mean, this judge basically feels like he's yelling at children and scolding them as if they were children. Both very experienced lawyers, been doing this for a long time. And the judge even mentions that. But the judge is not happy and will control his courtroom.
You'll have a chance.
Oh, I know, but he should.
You'll have a chance.
I know
Wait till
he's
he
doing
finishes, then you will have a
that.
chance.
I know what he's doing that.
Do not interrupt.
And Taco Pina's like, I know what he's doing right now. And he still keeps talking, even though the judge is telling him to stop. I'm going to make myself smaller so you can kind of see the judge's interaction with them. But what he means is, I know what he's trying to do. I know what he's doing right now. He thinks the prosecutor is speaking to us, right? The public, the press, the media, the people watching this trial. And he doesn't want it to go without him getting his word. And the judge is like, you will have your chance, bro. Relax. By the way, they're talking about, I think, some comments that this lawyer, the defense lawyer, made to the public that I saw on TMZ or something. It's like a short 2-minute interview where he's talking about the jury. We will play that so we can understand the context of at least some of the public comments being made and whether we agree with the prosecution or the defense.
Neither of you interrupt the other.
He said, I need to say something in open court. And then he made a statement about how they were very happy with the jury. Clearly, it didn't matter to the court. He then asked to approach. When we asked to approach, he said he wanted to do it on the record. On the record. But outside the press, he then complains about jury selection, about a specific juror, etc.
So that's interesting because, number one, we talked about this in one of the prior videos. I was like, I thought he said he was happy with the jury, but he's arguing about it. But it's okay. The defense did exactly what you should do and protected the record by saying, because you brought this new expert in and we have different ballistics discussions now and evidence you didn't turn over and discovery you didn't turn over, it may have affected my jury selection, Judge. At least one of the jurors, I think it may have affected whether or not I want them on. And again, you have to realize this lawyer's thinking on the fly. He's just trying to deal with the new information he's gotten. He just picked the jury. He's got a lot going on. I think he made the absolute proper protection of the record by saying this may have changed my jury selection. It didn't seem like he said he hated the jury or anything like that. And loving the jury maybe wasn't even that inconsistent if you understand his argument that things could have been different, and that's very important. But the prosecutor is trying to make it into this, oh, he says he loves the jury in front of the press, but he says he hates the jury behind closed doors. He's trying to make them look bad and like the defense is playing up to the press. That's what this feels like to me so far. Again, the interview we're going to watch will give more context to this.
We are not going to participate in Mr. Tacopina's attempts to manipulate the media.
Mr. Tacopina's attempt to manipulate the media. So he thinks he's calling it out, right? He's not pulling any punches, and we're going to hear why, because there were some more things happening in the courtroom than we saw. And some people have mentioned that the defense lawyer, Mr. Tacopina, is a little built. You know, he fills out his suits, to say the least. And we're going to hear some stuff that happened in the courtroom recently.
Again, that ties into the fact that when the case started, I very kindly said to Mr. Tacopina, hey, listen, I know you've been speaking to the media before trial. There was no worry of every right. Are you going to be saying anything once the trial started? He assured me in front of my co-counsel, the response was, John, I would never do that. I won't be saying anything to the press. Meantime.
So he said, listen, I know you've been talking to the media before the trial. That's your right. Are you going to be doing that during the trial? First off, you don't have to tell the prosecutor what you're going to be doing during trial. But he says, Tacopina said, no, I would never do that, John. I'm not going to talk about it during the trial. Even my co-counsel heard him. And then we have this.
He is speaking, I resent the court this. He's speaking to TMZ. He likes to say things to the press as he leaves the building. We took him at his word that he wasn't going to be talking to the press while the pendency of this trial was going on.
And again, saying stuff like we took him at his word means he's lying now. His word is no good. You can't trust his word, Judge. He's talking to TMZ and all these outlets. Again, reserve ruling until we hear it. And what he actually talks about. And remember the context that lawyers are allowed to talk about their cases. They're allowed to talk about things in the public record. They're allowed to talk about things that don't prejudice the process, that don't claim a witness is lying or a victim is lying or a defendant is guilty for the prosecutors and things like that. So there are rules, but you are still allowed to generally talk to the media under certain circumstances, especially, during a trial when there's public interest and they have questions and things that are happening in court that are open to the public, especially and being streamed. It's okay to talk about them.
This is necessity. As an example, we ended up hearing his arguments basically about the jury issues repeated by Al Sharpton. We're not going to try this case.
And the comments that Al Sharpton quoted or repeated, I didn't hear Al Sharpton say them, but you may have an idea or a guess as to what they are when we watch the 2-minute interview.
Press. We're going to ask the court at this point to order Mr. Tacopina to not speak to the press during the pendency of this trial.
Okay, I guess I'll start in reverse. First of all, I'd like him to provide a quote of what I said to the press, because one thing I've never done is speak about the facts of this case.
He says, Your Honor, I can quote what I said to the press, because if it's one thing I never done, it's speak about the facts of this case. So now is the time. He's going to make more arguments, but now is the time. We're going to pause here for a second, and we are going to bring up the interview and listen to exactly what he had to say. This one's a little louder than the court volume, so everybody adjust your volumes appropriately. And let's just listen to the 2 minutes of what Mr. Tacopina had to say after the first day of trial. I think this was last Friday. This is what they're arguing about. This is where the prosecutors say, order him to stop talking about the case, Judge. And remember what the rules are. I think it's Rule 3.6, rules of professional conduct in California, ethics rules for lawyers, what you can talk about, what you can't talk about, and see if you think he violates any rules with this.
How'd you feel like the first day went?
Well, very well.
Yeah, you think so? Are you obviously really upset?
By the way, sorry, people get annoyed when I stop a lot. That's kind of the point of this channel. Also, I'm repeating a lot of what the lawyers are saying because it's kind of hard to understand certain parts in the courtroom. I'm boosting the volume as much as I can, but the repetition helps us learn and figure out and actually hear what's going on. He's being kind of like bombarded as he walks out of the gate. He seems to be friendly to the press, okay? Seems to know a lot of people out there. He seems happy to talk to them, but it's not like he sought them out. He didn't have them set up a press conference. They come up to ask him questions as he walks out of court.
Upset about
Hey, Harvey. Hey, Charles.
you obviously were really upset about the evidence being turned in late last night.
Yeah.
What are your thoughts on that?
Sort of what I said in court. I don't want to be rehashing it, but, just a matter of making sure my client has a fair trial.
Yeah.
I'm going to leave it what I said in court. You know what that is? That's on the public record. I want my client to have a fair trial. That's totally appropriate in my estimation. You guys let me know in the comments, though, if you disagree. Let me know.
And fundamental fairness is really something we have to ensure, and I'll fight as hard as I can to make sure he has a fair trial.
Do you think he'll get a fair trial?
That's my goal, is to make sure he gets a fair trial.
It seems like you are unhappy with the jury selection.
No. I'm not unhappy with the jury selection. I love this jury.
Yeah.
I love this jury. I think it's a good jury. We didn't use all our challenges. What I'm unhappy.
Now, that's interesting. I didn't know that. They didn't even use all their peremptory challenges, which waives a ton of appellate issues for jury selection. But my guess is the newly discovery, I don't know if it's going to be evidence yet, could change that and change some appellate issues. But in order to have an appellate issue, like there was a juror that came on, you didn't think should have come on, you think should have been struck either for cause, or you would have asked for an extra peremptory challenge. You have to use all your peremptory challenges, which is the challenge that you can strike a juror for any non-discriminatory reason. Cause challenge means they can't be a fair juror, so the court has to agree with you to strike those. It's unlimited. The peremptory challenges are limited, different per jurisdiction, per case. But he's saying we didn't even use our peremptory challenges. So in order to get to the appellate issue, you have to use your peremptory challenges. You have to say, Judge, I want an extra peremptory challenge. If the judge says no, you say, I would have used it on this juror because of this reason in order to continue to keep and protect that appellate issue. So he doesn't even have those because they didn't even use all their peremptory challenges, which I got to be honest, that's putting your money where your mouth is. That's proof that they like this jury, because if there was one person they didn't like on the jury, they could have struck them. I don't know if they had one left or more than that, but I believe him because he could have literally struck anyone on this jury if he wanted to with his extra peremptory challenge that he didn't use.
Happy with is the fact that in Los Angeles, downtown.
sorry, he's saying what I'm unhappy with, and now he kind of goes into a spiel that is a public policy, a thought, and I agree with it, right? I agree with this. I've talked about this before, that whatever the race, age, gender of your client is, it is very frustrating and sometimes mind-boggling to be like, there are no jurors that fit this. Doesn't have to be a full jury that looks exactly like your client. That's not a jury of your peers. But generally speaking, when you hear his issues here, you're like, yeah, that is frustrating. That is annoying. We need to figure out a better way to do this because that's problematic. That's what he's going to talk about. It's kind of like a general thought process that this was an illustration of. That's his main gripe here. Let's listen.
We didn't use all our challenges. What I am unhappy with is the fact that in Los Angeles, downtown Los Angeles, we didn't even see one black juror. We didn't even get to say hello to one black juror. And, he's supposed to be judged by a jury of his peers. And, and that's no secret what I'm saying. We made a motion in court. We made a writ of mandamus. So, it's wrong. It's just wrong.
And he makes sure to say, we made a motion in court, made a writ of mandamus. This stuff is all public. He makes sure to do that.
I don't know how it happens, but out of 106 jurors, I saw Reverend Sharpton's statement, out of 106 jurors, 4 were African American.
Okay, so maybe he quoted Sharpton, not the other way around.
And out of the first 40, there were none.
Yeah. How do you think this will affect the trial or the outcome?
At the end of the day, I don't think it will at all. I like this jury. I think they're smart. And look, we selected them. So,
yeah.
But it's just a matter of, making sure a fair cross-section of the community is represented. And it's not.
Yeah.
Okay.
What
do
you think about Eric Jane's son as the police officer? Real Housewives of Beverly Hills, very famous woman in Hollywood. Her son is the one that was the officer.
Oh, I have no idea.
Yeah.
That's fine.
It's fine.
Hope it takes stand.
Yeah.
I enjoy Cross. So.
And then, of course, he says, I enjoyed Cross. So, again, you guys tell me what you thought. I don't think he commented about any of the facts, any of the witnesses. I don't think he was trying to poison a jury pool or have, if the jurors were to see that they would be offended by something he said, or he was trying to convince them one way or the other. I actually thought it was pretty benign, and he tried to protect as much he could. Now, let me just say this. That's that one interview. He could have given other interviews. I don't know. I'm sure he's a big shot lawyer, and I'm sure he does things in the media all the time, as many lawyers do. Again, as we've been seeing a lot more of that lately. I'm not saying he hasn't tried to manipulate the media and do something to make them, think this is unfair or think A$AP Rocky is innocent or whatever it may be. But that interview that they're referencing, to me, was pretty benign and appropriate for what he had just gone through that day, for somebody basically grabbing him at the courthouse steps, asking him a couple questions. He even tried to keep it to everything that was public record. So there's more though. There's more coming.
Never. Okay. But I do have here a quote from the district attorney.
So he says, oh, you're going to come at me with public interviews to the media? I've got a quote from the district attorney from an interview he gave.
Mr. Hoffman, who did quote to Extra that he appreciates any time defense counsel is pretty sure they're going to prevail, but we don't bring cases unless we're very sure we can win those cases by establishing and meeting our burden of proof beyond a reasonable doubt. I believe that when we see the evidence that's going to be presented in this case, we'll meet that burden. So that's the issue.
So he talked to Extra and he said, well, we always appreciate when defense counsels are confident they're going to win because we don't bring a case unless we're confident we're going to win. And I think when you see all the evidence, you're going to see we can prove guilt beyond a reasonable doubt, or whatever he said, which theoretically to me falls more into what you're not supposed to say as a prosecutor when we read Rule 3.6. So to make those comments to Extra, and it seems like the defense attorney may not have brought him up, but to make those comments and then to call out that the defense attorney is trying to do things to manipulate the case is like, that seems more along the lines of exactly what they tell prosecutors not to do in the professional responsibility rules, not to say somebody's guilty publicly. And if somebody is arrested and you're going to prove the case, these are just allegations, right? These are just allegations and there is a presumption of innocence. That's really what the prosecutor is supposed to be saying. That's what all lawyers should say in this situation. He sits there as an innocent man until the prosecution clears the burden of beyond a reasonable doubt. So I found it very interesting. The defense lawyer in this case is loud, is big, he's a presence, right? I mean, he's got a certain presence to him. You can tell. He slams the table. He gets up. He yells a little bit. The judge even told him to be quiet a couple times, just kind of like lower his tone. He's got that vibe. So I get it. And, you know, prosecutors like to be like, oh, this guy's kind of a big bully jerk. But if I'm just looking at and I don't know the whole context. I didn't listen to the whole prosecutor's press conference, or whatever he told Extra, but that's not great, especially if you're calling out somebody else for manipulating the media.
District attorney. Okay, so I should be able to rebut something like that. That's different. That's saying we're going to win the case. We know the evidence, and we'll meet our first. I talked about nothing other than the potential issues with the jury. I didn't speak about the facts. I didn't speak about Mr. Efron, and I won't do that. Now, the last thing he said was I spoke to TMZ. Again, I defied to provide to the court what I spoke about because I didn't violate any order. First of all, there's no order. But I certainly, I know enough not to speak about the facts of the case. By the way, I didn't open statement to the jury. Certainly, I would never say anything outside of that opening statement. I didn't even do that, Your Honor. I simply talked about the issue with the jury. And the reason I did that is because he just did again what he did the other day. Stood up and said, we're not happy with this jury. Try and get that message back to the jury that we're not happy with them. That is not the case.
So he accuses now the prosecutor of trying to get the message that the defense doesn't like you, the jury, back to the jury. Well, how would they do that? Well, if the jury watches it on YouTube, if there's some kind of news report on it and the jury's watching the news, or somebody who knows a juror is watching the news and they say, hey, did you know the defense attorney doesn't like you guys? The defense doesn't trust you. That's obviously not good. And he thinks the prosecutor is trying to do that on purpose, which would obviously be horrible. And I don't know that he's trying to do that. I think the prosecutor is probably trying to just stop everybody from talking to the media and stop this, you know, big shot lawyer from coming into town. And he definitely gives a vibe of like, you don't know what it's like around here. I think this lawyer's from New York, maybe. I'll have to look that up. But I think this lawyer's from New York, this defense lawyer. So he's kind of trying to home team him here a little bit too.
But, Your Honor, the reason I raised the issue about maybe we would have selected a different jury, or certainly a different juror or two, is because of the late disclosure of the ballistics report after a jury was impaneled. And we have a right to make that record. It doesn't mean I'm unhappy with the jury. So, you know, speaking of disingenuous, we're going to now get into disingenuous. But I did nothing but protect the record, protect my client. So that's first and foremost. You know, so again, the issue that I spoke about off record was caused by their late disclosure of
yes, he's from New York, and this is in LA. And so obviously the prosecutor practices in LA. So he's like, he doesn't know what it's like around here. It's kind of like if a Miami lawyer goes up to Tallahassee, it's like, listen here, we don't trust people from Miami.
report that was generated over a year ago by their lead detective in this case. That Mr.
He kind of rehashes the stuff with the new evidence that they've already discussed.
Lewin wants everyone to believe he just stumbled upon 3 days ago. He just stumbled upon 3 days ago.
You don't have to whisper, just talk.
Try to get that middle ground.
Just talking.
Through the judge is like, just relax. I get it. I have that happen to me sometimes too, especially when the jury's not there and I'm not as cognizant of, I start to get excited. I start to use my hands a lot. I start to get louder. I feel his pain a little bit. And the judge is like, relax. And he's like, okay. He's like, you don't have to whisper. He's like, okay, I got to find the middle ground here.
That he just stumbled upon 3 days ago. You know, he made all these accusations about that's disingenuous. I don't believe it. Well, I don't believe that they just found that report from their lead detective who they interacted on a daily basis in this case.
He's like, they keep saying we're disingenuous, all stuff. And I don't believe it. You know what? I don't believe him. It's there's no love lost here, as they say, between these two lawyers. So this is going to be a battle. They're not going to give each other an inch. They're going to continue to make arguments that one lawyer is doing something inappropriately. They're going to keep making arguments that they're doing something that's underhanded, that it's not fair, that they're violating rules. You can just see that that's going to continue throughout this entire case.
3 days ago. I don't believe it. That was done January 2020.
I already made findings.
I understand.
In my view, nothing nefarious. I don't want to go over things that we've already gone over.
Well, we just did. We still have to do it.
He's asking that there be that both sides be directed not to make comments to the press. That's what he's asking for now. I'm not poking fingers. I'm not accusing anybody of any unethical conduct. Let's just move forward. Here's what I want to ask.
I do things.
Oh, go ahead.
All right, I just listened to it.
Go.
Now, we heard a little about the discovery issues about, this not being enough. I mean, I think this is incredibly detailed when it comes to Mr. Phillips, especially if this is a videotape. This is really detailed. detail, tell us what he's going to observe at the scene, what he's going to testify to, what he observed at the scene. Putting that aside,
Based on what I've heard, I am satisfied, under the circumstances, that both sides have satisfied this discovery rule.
so
So there's no reason to go over about whether you have complied with discovery. I already found that you did.
okay, now I want to talk about Ben. There was a police officer, the first one out of the box, Sergeant Zizzo.
Right.
The only thing we have from them, because, I assume the rules apply to both sides, right? The only thing we have from
That was a bit of sarcasm. I assume the rules apply to both sides, right?
them, there's a two-line email saying we spoke to him on Wednesday. He testified Friday before. We spoke to him on Wednesday, and Jack, you have the emails? That they spoke to him on Wednesday, which they also denied on the witness stand, by the way. He said the first time he spoke to him on substance was the day of his testimony. He said that he advised the district attorney that he responded to the shooting while on patrol, and
By the way, the bag says Harvard Law School. Good ad placement for them.
it's common occurrence that the receiver called the shooting and respond only either to find no evidence or the victim, but also sometimes find out whoever called was intentionally misrepresented. 2 sentences, that's the discovery. He testified that one, he may have missed the bullet casings, and 2, he didn't know where to look. 2 sort of important things and he didn't agree, he didn't search the entire street. That was not in their disclosure. Not their disclosure at all. But yet I'm being accused of not giving them the right information. First of all, I don't have the date. There's nothing in their disclosure that they interviewed him Friday before his testimony. We don't even have that interview. We don't have that date. We have Wednesday only. The witness said, no, I didn't speak to him on Wednesday or something. That was just about logistics. Okay, so before we start casting aspersions, I wasn't going to even raise it, Mark. Just happened. I understand this is trial. But, being that we're now throwing stones, let's hold the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
So he's like, Judge, now that we're casting dispersions and throwing stones, the judge's like, how about we don't? How about we don't throw stones? He's like, well, they throw stones first, so I'm going to respond. I'm going to throw stones back. This is happening in a courtroom. And by the way, on Tacopina's website, which I looked up to see if he was in New York, it says, outside the courtroom, Mr. Tacopina deftly defends his clients in the court of public opinion and is equally adept at keeping clients away from the media spotlight. The matters he works on frequently capture the nation's attention, including a successful effort to free rapper Meek Mill from prison, the investigation into the disappearance of baby Lisa Irwin, Major League Baseball's investigation of Alex Rodriguez, and the acquittal of the Sopranos actor Lilo Brancato on murder charges. Mr. Tacopina frequently appears on major national media outlets, including CNN, Fox, and Newsmax, and can also be heard on his weekly appearances on WABC Radio's Sid and Friends in the Morning in New York. So he's in the media, right? He gets it. He knows how to use it. And this is probably part of why the prosecutor talks about this. But let's hear them go back and forth on the judge. Like, listen, I don't want this to be a throwing stones contest here.
But before we start casting aspersions, I wasn't going to even raise it, Mark. Just happened. I understand this is trial. But, being that we're now throwing stones, let's hold the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he swallows. Well, I'm swallowing back.
Well, you're a good squabbler. You're doing a good job squabbling. All right. Regarding what Sergeant Zizzo testified, did he write a report?
He did not write a report, Your Honor. But he obviously wearing body worn video.
That's been provided.
That was provided.
All right.
Years ago.
You're an experienced attorney. All of you are experienced attorneys. Sometimes, a witness will say something that is not in a report. That's to be expected. A report is a summary, a sum and substance of what the witness said. It's much more fleshed out when the witness is on the stand.
Well, I agree with that. I'm okay with
That's true, unless of course it's an undisclosed expert opinion that could make it very different. But generally, yeah, they all are going to agree with that, and that happens all the time. You can even prep a witness. Sometimes they say something that's not good for you, and they're your witness that you didn't expect that wasn't in their report. That's why we talk about trial law being something you've got to adapt to. You've got to be ready for anything. You've got to be quick on your feet. You got to think quick. You just have to be doing 50 things at once. That's just what trying cases is all about.
I'm not even gonna raise the fact that he said he didn't speak to them on Wednesday and he almost spoke to them. I don't do that. It's petty.
It is petty.
But I want to make sure that what's good for the goose is good for the gander. That when Mr. Phillips testifies and he says something, a word that's not in this thing, it's not like, you didn't tell that to the lawyers because it's just not right. No one, this is not a transcribed statement. There will be nothing outside of the scope of this. But the same way I didn't get anything from them regarding, I may have missed the shell cases. I didn't get a report that said that or a statement.
Again, to be repetitious, I do not find either side has violated any discovery statute or any discovery rule. Regarding the press, the jury has been told not to read or watch anything about this case. I'm going to assume that they followed that rule. But what I am concerned about is
That's how the judge says, I'm going to assume, because we all know, no guarantees.
someone that the jury knows is going to read or watch something about the case and then relate it to the jury. So here's the rule. I don't want any attorney in this case saying anything to the press while the case is going on. That's it. So you can call it a gag order.
We will advise, obviously, of course, where we've said nothing. We will advise the DA as well. To be clear, the DA responded to Mr. Tacopina's published report where he dared, quote, Nathan Hoffman to try the case himself. But we're going to tell the
He said, well, we'll talk to the DA, judge. We weren't saying anything anyways, but the DA felt like he had to respond when Mr. Tacopina said he dared the DA to try the case himself. I mean, you can't make this stuff up. You really can't. But there is a gag order now. The judge is telling both lawyers not to talk about this case in the media, so we don't expect to see any other interviews in the future from either of these lawyers or any of these lawyers.
Let's move forward. Yeah, just let everybody know in your office who may say something, tell them not to say anything to the media or the press.
Will do, Your Honor. We had two last issues which are brief. The first issue is we're going to request, we made this request before. Counsel and I've tried many cases in front of the court. If there's anything even close.
And he just kind of like leads into it quickly as if it's not going to be a big deal. But he's like, I have a couple more issues, Judge. I'm very experienced too. And then he's going to go into a very shocking accusation here against the defense lawyer, who I might just point out here while we watch the muscles bulging through his suit jacket here as he's about to make this complaint to the judge. The prosecutor is going to make this complaint.
Counsel and I've tried many cases in front of the court. If there's anything even close, I forward to in advance. If there's any evidentiary issue, which is even a close call, in terms of the defense interviews and bringing up, ask a question, we want to make sure that they ask an approach and that we forward to it. You don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, the court is aware. On Friday, it doesn't really matter what circumstances were. Mr. Tacopina literally started screaming at me. So again, Your Honor,
And if you notice, Tacopina every time was like, oh, come, you got to be kidding. Every time he starts this out with saying, Mr. Tacopina was literally screaming at me.
I'm not interrupted, Mr. Tacopina.
Did you see it? I didn't even notice this the first time I was listening. Tacopina goes like this. I mean, this is like, I'm laughing and this is like entertainment value, but my goodness gracious. Like, dude sitting next to him could be going to prison for, I think, 24 months. Like, this is a serious case. You're accusing him of shooting somebody, right? This is a very serious case, but I mean, these are two lawyers that are really just kind of fighting like this, it feels like, with each other. But Tacopina's like, oh, boo-hoo, as he's making this complaint that Tacopina was screaming at him. And I think he goes as far as to say, it looked like he was going to try to fight me, Judge. And again, look at Tacopina. It's like not a dude you probably want to have a scrum with in the courtroom. But listen to this description from the prosecutor.
So again, Your Honor, I'm not interrupted. Mr. Capitan lies. As I speak, Mr. Capitan makes noises, again, if there's gotta be a certain decorum. We're following it. But, you can't bring a knife to a gunfight, so we would appreciate, as the court is respectfully instructed, there were one
Can't bring a knife to a gunfight. It's not a great pun here for this case.
talking, the other were not interrupted. Mr. Capitan, as far as aware, started literally screaming at me in the courtroom. He basically appeared to challenge me to a fight.
He appeared to challenge me to a fight. Did you see ASAP Rocky's head turn? He was like, what?
Appeared to challenge me to a fight. And again, I've been doing this longer than he has. I've not had that experience occur before.
Nobody seems real fond of this prosecutor right now. He's like, I've been doing this longer than him, and I have never had this happen before. It's like, yikes.
I'm not going to be treated that way by anybody. I'm certainly not going to be treated that way in a court where I practiced for more than 30 years in front of a judge I deeply respect.
So it sounded like he was going to say, and then he almost caught himself. He's like, I will not be treated that way. And I don't disagree. Don't be screaming at me and act like you're going to fight me in the courtroom. Okay. Tough guy. That's what I would say if a lawyer did that to me. But he's like, I'm not going to be talked to that way, especially, and it sounded like he was going to say from some New Yorker here in my hometown of LA. But he's like, instead he was like, in a courtroom I've practiced for 30 years in front of a judge I deeply respect. But that's reading between the lines. Lawyers get very territorial. And when a lawyer from out of town, you've seen it already with me and Emily talked about it on our podcast with the Jay-Z and lawyer Spyro and Tony Busby, and how it's happened to Spyro in the past with these pro hoc vices all around, lawyers practicing all over the place, different rules, different vibes. And sometimes the hometown lawyers don't like it. They don't take a liking to it. And they try to get the judge like, hey, this is our spot, judge, not his. We can't have him come in here and, running through walls and stuff. That's not how we do it over here. Now it's LA. It's not like some small town or something, but still interesting.
He doesn't have to like me. He doesn't have to get along with me. But he cannot be screaming at me, whether on or off the record. The court was here. The court, everyone heard and saw it. Not right. So I'm just asking that the court, again, Mr. Captain is an emotional guy, that the court advises him.
And you are, both of you are zealous attorneys, aggressive attorneys, both of you are.
We are due to zealous aggressiveness. The court has not heard of me yell or scream at anybody. And again, and it's not a
Said Mr. Tacopina is an emotional guy, and the court's like, well, both of you guys are zealous, aggressive advocates. He's like, well, there's a difference between zealous and aggressive. And I think this guy is, he's a savvy lawyer. I think he's needling Tacopina a little bit. I think he likes to get under his skin a little bit to rile him up. And Tacopina seems like he might be easily riled up. So we'll see how this is just the beginning. This is day 2 of trial. I have a feeling they're going to get on each other's nerves plenty.
I'm not going to take that.
All right. What are we
I'm not going to take that, Judge.
I did not hear you yell. I did not hear it. If it did happen, it wasn't in my presence. Because you two have this relationship, why don't you not?
Because you two have this relationship, it's like, because you guys hate each other, and now the judge has to, play babysitter. This happens sometimes. They got to play mommy when the kids are fighting. Like literally, this has happened in lots of cases. And so he's going to try to come up with a solution, but it's not great.
This relationship, why don't you not talk to each other unless it's on the record?
Oh, that's,
And then I am involved.
that train is sailed. Yes, absolutely, I agree with that. But I want to respond.
He said that train has sailed. He's a man after my own heart, messing up one-liners. That ship has sailed or the train has left the station. But I have had this with cases. So if I think the other lawyer is just a total liar and I can't believe anything they're going to say, I won't say where they may have been from, but I will do that too. Be like, Judge, I don't want any personal phone calls. Everything has to be done in writing from this point forward. Email, file it with the court, whatever it may be, but I don't want any phone calls. I don't want him to reference any phone calls. I'm not agreeing to anything in any phone calls. And the judges hate that. I've had a judge be like, Mr. Tragos, I think that's too far. And I'll be like, Judge, I don't want to put myself in that situation where he's going to say I said something that I didn't. So, we've had to do that in cases before. And so the judge is like, everything has to be done on the record in this case. And Taco Pina's like, you're speaking my language, judge. Don't threaten me with a good time. I agree. That's already how it should be.
Because, I can't have it always one way. He makes a record disparaging remarks, and now I gotta sit here. So, no.
And he's like, judge, you can't have it just one way where he makes disparaging remarks on the record and I just have to sit here. He's like, he's ready to explode. That's how lawyers are, right? Lawyers have to make their record. They have to make their argument. They have to respond when somebody says something about them.
Don't scream, you're right there, Your Honor. What's happened, and Mr. Siegel was with me, is Mr. Lewin comes up with his little scolding, sort of bullying attitude, telling me we don't know the rules here, and we're not doing this right, and he didn't like the opening statement, and so on and so forth. So I respond, I don't need a lecture from him, okay? I'm not gonna go into the amount of phone calls I got regarding him and his reputation before this trial started, from lawyers I don't even know, including lawyers inside the district attorney's office currently, okay? I'm not gonna go into it, Your Honor, 'cause I'm not petty.
No, and now you're interrupting him. Just that, you were complaining about him interrupting you, you're interrupting him. Don't.
I'm not going to.
Oh, the judge is like, listen, you've been complaining the whole time that he's interrupting you. And now you do this? Don't.
I just don't want to do that, but please, there was no one yelling, you were right here, there was an argument between both sides, both of us, I agree. That's not gonna happen, because I'm not gonna speak to get off the record, so you're right about that, that's number one. Number two, I have to also raise an issue, and I'm not past that, I don't want to talk about that, Your Honor was here, that's the end of that. Mr. Lewin did something last week that was inappropriate. The reason I'm raising it is because I don't want it to happen again. This week, Mr. Mayor's significant other may appear here. Last week, Mr. Lewin is his play.
P.S. His significant other is Rihanna. So that's kind of a big deal, right? If she shows up. And I'll let him finish this thought. This will be the last thing we cover here in this video.
Apparently, one of the lawyers went up to my client's family and told my client's family that's not personal, but they should really, hopefully, he's really thought about taking a plea because he's facing a lot of jail time, and saying things that played on the emotions of the family. He should have no communication with the defendant's family. I've heard he's done that in every case. That's right here. Well, I don't want him, and I want the court to instruct him not to communicate with anyone on this side of the fence, not the client's family.
So he's saying he went up to the family and was like, oh, he should really think about taking that plea deal. And by the way, prosecutors can talk to the defendant's family, theoretically. They shouldn't. And the defense lawyer should be like, hey, all of you people involved, just tell him to get away from you. And he has to get away from you. You don't have to listen to him. You don't have to talk to him. But now he's going to have the judge instruct him not to talk to the defense, anybody on the defense side.
Family, not punch roll, not punch friends, because it's inappropriate.
So, Your Honor, so what happened was, I walked up very kindly to the defendant's mother and sister, and I said the following: "Listen, I'm very sorry that you're having to go through this. I have kids myself, I have siblings myself, I know it's not difficult, it's not personal, and I'm truly sorry for what you are having to endure."
All right.
And then I said as follows: I hope that your brother or your son, I hope that he's really evaluated what he's risking here, because he is a lot.
All right, there's nothing that prohibits,
At the time.
I've heard enough, I've heard enough. There's nothing that prohibits what Mr. Lewin did. You've heard now that the defense does not want you to approach anyone from that side, so don't approach anyone from that side. It's as simple as that.
He says he agrees. And he even made some comment like he has a reputation for doing this in this case. I've talked to lawyers and I know he does this.
All right.
Your Honor, again, this is one evidentiary issue we need to deal with.
All right. That's it. So, I mean, what a battle it's becoming. I think the fireworks are just starting in this case. I really do. But you guys tell me, are you following it? Are you interested? Do you have questions? Do you want to daily recaps, weekly recaps? Tell me what you guys want. Anybody that is watching this, make sure you guys hit that like button and subscribe so you don't miss any future videos we put out on this trial or any of the others that we're covering. But For this video, that's all we got. I'm Peter Tragos, the lawyer you know. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.